Hello, welcome. My name is Dr. Elisabeth Griffiths, and I am one of the trustees and board members of the Socio-Legal Studies Association. And I'm delighted to be joined today by Dr. Jaime Lindsey, who's going to be talking about her book, Reimagining the Court of Protection, Access to Justice in Mental Capacity Law. Jaime won the Hart SLSA Book Prize for Early Career Academics in 2023. So thanks very much for joining me today, Jaime. Welcome.
Thank you very much. It's great to be here.
So I just wondered if we could start by perhaps just telling us a little bit about why you were drawn to this particular area of research. You know, it's got a particular socio-legal angle, which will be of interest to the people watching the video. So why did you want to do this area of law?
Yeah, thank you. So I think generally I'm very interested in taking a socio-legal approach to my research. And that's, I guess, because I like to see how people interact with law in the real world, in their everyday lives. So how people interact with the news law in different ways. And obviously that's within the court context, but not exclusively so. And I think so by background, I'm a healthcare lawyer, and that's kind of where I started. And I'd actually been working in practice as a trainee solicitor in a healthcare law firm. And I'd been seeing, the way the Mental Capacity Act, the Court of Protection was used in real life cases. And it struck me kind of just how different that was from, the law that I'd been taught at law school, and how law in real world in practice, really has a very different emphasis and a kind of different effect from sometimes how we're taught it. And I think that kind of led me down the road of wanting to actually research and report on, through empirical research, what was actually happening in practice in this jurisdiction. What kind of processes and procedures were being used in the Court of Protection, what sort of evidence was being drawn upon, even tactics by lawyers, all of these things that kind of surround the court process were not really being talked about in mental capacity law in the Court of Protection at the time when I started this back in 2014. It was a lot more kind of heavily doctrinal and looking at substantive law. And so that's kind of what inspired me to do this project, to kind of uncover what was actually happening on the ground in the Court of Protection. And at the time, the Court of Protection was perceived as quite a closed, almost secretive court, which I don't think is necessarily always fair. It has opened up a lot and has, made real strides. We've seen in the Open Justice project in the pandemic, the Court of Protection has made a lot of improvements in terms of openness. But yeah, at that time when I started this research, that was really what kind of inspired me to shine a bit of a light on what was happening in this jurisdiction.
Hey, brilliant. I mean, it is a fascinating book. I really enjoyed reading it, and it's very accessible as well as a read, if I can say that, because I didn't know much about the Court of Protection. I do disability work, but I didn't know much about that particular court. So it was fascinating for me to read it. So thank you. It's brilliant. So that's sort of the aim of your monograph, then, I suppose, and the background to it. So you were inspired to do it by that sort of practice work as well that you had done previously. And I always think that's a really that informs a lot of socio-legal work, I think, which is brilliant. So if we move on to the actual monograph itself, your overarching aim, as you said, was obviously to explore this sort of sometimes quite secretive court that not many people know about, and you use a variety of data sources in the book. So could you just tell us a little bit about your methodological approach and obviously some of the ethical issues that you encountered, because it's quite a sensitive area that's been researched?
Yeah, definitely. And there's lots of ethical methodological issues which I can touch on. I wonder, would it be helpful if I just first explain, who is affected by the Court of Protection, just in case people are less familiar with it? So the Court of Protection is the court that deals with disputes under the Mental Capacity Act, which is an area of civil law in England and Wales, which applies to people, well, applies a test as to whether or not a person lacks capacity to make a particular decision. And then if they do lack capacity, then a decision can be made in their best interests. What that means is the vast majority of people who are impacted by this jurisdiction have a disability, have some kind of mental impairment. And so that's kind of one of the other kind of key aims of the book, is to uncover, does the Court of Protection achieve access to justice for those people affected by it? So I think that's a really important thing, just to be clear about. And as you say, that feeds into a number of the ethical and methodological issues. In terms of methodological approach, I would say that I was very much influenced throughout my PhD by my supervisors, I just have to say. So Professor Rosie Harding and Professor Mary Fox, they really I took a lot of influence methodologically from them about looking at law in everyday life. But in terms of the methods that I actually selected, there's quite a number. So firstly, I observed court cases at the Court of Protection. So I think that was around 8 cases across a number of hearings. I also accessed 20 Court of Protection case files at the London Registry of the Court of Protection. And I, as part of the PhD empirical work, I also interviewed social workers so historically the Court of Protection has had quite a medicalised focus, and I wanted to move away from that and see kind of how social workers were also viewing mental capacity law in practice. Subsequently, so that was sort of 2015-16. During the pandemic in 2020, I also went back and did some virtual observations of court hearings to kind of see what had changed and things, how things were done differently, which was really, really interesting. And I can talk about that further if you'd like me to. And then I also did another project which was funded actually by the SLSA, by one of their research grants, which looked at the use of mediation in the Court of Protection. So I interviewed mediators and lawyers. So all of those kind of quite different data sources were brought together for this book. And then I kind of analysed it through procedural justice kind of lens. That's a quick overview of methods. In terms of ethics, so there's a lot, probably quite a lot I could say about ethics and ethical challenges. I think getting access in empirical socio-legal work is, one of the most difficult parts of doing this kind of research. And the ethics processes that you have to go through are lengthy. I think it took me, around a year or so to actually get access to the Court of Protection through meetings with the Vice President of the Court of Protection at the time. I had to go through the Ministry of Justice Data Access Panel to get access. And gosh, there's lots of ethical issues, but just to give a kind of flavour of one, I think, ethics committees expect you to, doing something like observational research, kind of have a very clear idea of how they want you to get consent from participants, kind of this very linear process, getting written consent, and then you go off and do the research. But the reality, as many ethnographers would have said before me, getting consent from participants on the day in that kind of messy reality, they're at court, they're going through a process, is much more complicated and much more of an ongoing consent process. So I think I learned a lot from doing that research and kind of about building flexibility into ethical applications and kind of designing ethical research. I think, the research at the Court of Protection taught me a lot in that regard, but I don't know if there's a particular thing you'd like me to pick up on. Or...
Yeah, it was just fascinating for me looking at all of the different data sources that you had used and analysed throughout the book, and that's what gives it such richness, which is the bit that I really enjoyed, looking at all of these different aspects. And I know, particularly maybe for people starting out in socio-legal research, thinking through some of these methods and ethical issues and so on. So hearing how other people do it, I think, is always really useful. And that sort of messiness side of it, I think, certainly when you start out in research, you think it's all going to be lovely and perfect, and then you realise it really isn't. So no, thank you for that. That is really, really interesting. Thinking through sort of beyond how you collected the data then. I suppose it's also to think about what you did with it, the lenses through which you analysed that data. And I just wondered if we could talk a little bit about the theoretical framework that you used, this concept of procedural justice. And I was really interested to hear, to read about the bits about embodiment, why you thought that particular approach to our understanding of procedural justice in this context was necessary. Really, I got the that you felt it was really necessary to do it that way.
Yes, and so I think the book, in taking together kind of all that quite varied data, I was thinking through how to present it and what the aim was, and really I wanted to show, as I said at the beginning, the kind of practical procedural realities of how the court of protection kind of works for people, day to day. And for me, procedural justice was a really good way of analysing all of that data, because it enabled me to kind of move beyond quite traditional substantive law questions about capacity and autonomy and best interests, and to think again about how are people interacting with the rules, whose evidence is listened to, whose evidence is given weight and why, who is seen in the court process and how do they interact with court spaces, both physically and then subsequently virtually in the virtual courtroom. And so I felt procedural justice was a good kind of lens through which to analyze all of that. But I see procedural justice, as I say in the book, as a floor, not a ceiling. So it's it's kind of the bare minimum that I would expect the court of protection to be able to achieve to secure access to justice for the person who's subject of proceedings. Much more could be achieved beyond that, but if they're not even yet achieving some of those core aims around kind of participation and voice, neutrality, kind of securing trustworthiness and transparency as an institution, then I don't think they can go on to then secure those substantive justice aims. So that's a little bit about the procedural justice side. However, looking at the procedural justice literature, it became quite clear that it was often discussed in quite an abstract, disembodied way. So a lot of the focus is on people's experiences of justice systems and their voice, and this kind of very kind of rational, well-constructed, clear communicated voice. But actually, embodiment seemed to be missing, not in all of the literature, but in a large part of it. And the reason I thought this was so important for the court of protection is because the people impacted by the court of protection, their bodily experience, their physical presence, the way that they live through the world is actually really central to the court's decision making and the way that the decisions will impact P's life. When we look at disabled people with impairments, the way that they are going to interact with the court is going to be different from somebody without that impairment. And I thought it's really essential that that aspect of mental capacity law, or of the participants in mental capacity law, wasn't excluded. And so that's, I guess, why I wanted to bring that out and to draw out some of the what I saw, some of the gaps in seeing the embodied status of P through the Court of Protection's current processes, rules, just simply the way that they give information or the way that they facilitate participation, I think ignores some of those embodied realities for Ps.
Yeah, thank you. No, that really did come out in my reading of the book, and that's what really draws you into this narrative that you're creating about the Court of Protection and how it could be sort of different, reimagined, as you say in the title of the book. So moving on to that idea of participation and voice, which you talk about. Now, I know you didn't speak directly to P, the person, at the middle of these court proceedings for a number of reasons which you articulate in the book. But you clearly firmly advocate in your reimagining of the Court of Protection that participation of the person is key. and that they ought to be given voice in the process. Can you talk us through a little bit about how you think that might be achieved from the research that you conducted before we sort of move on to looking at some of these hierarchies around evidence and users and so on, which was also fascinating?
Yes, so I think the role of P in mental capacity law in court of protection proceedings specifically, it's a big issue, and it's an issue that a lot of people are talking about in this area, and lots of people are kind of trying to grapple with. Yes, it was not part of the research design initially to do research directly with Ps, but Ps were present in some of the cases I observed, and some of those stories come through the interviews as well. So hopefully I have given at least some perspective on that. But I think there are people who are doing research, trying to involve disabled people who have experience of these proceedings. I think the difficulty in this particular area is that people impacted by the Court of Protection are not kind of one single homogenous group. There's a very wide range of people impacted by this jurisdiction, wide range of age groups, disabilities, life experiences, different contexts. So it's difficult to kind of find those gatekeepers, I think, to conduct academic research with those groups. And I think I'll come on to some of the more practical suggestions in a moment, but I think in my view, the Court of Protection should be doing this. Okay, so they're the ones that are making decisions about P every day. And they're the ones that have access to be able to engage directly with court users and to understand, what their experiences are, from which, as I say later on in the book, in terms of design thinking, you need to engage with people who are using that court process and find out what is working for them and what isn't. So I would say, in the first instance, the Court of Protection should be doing a lot more around engaging with the users of their jurisdiction. They have the best access, they have the ability to ask those questions, and I think that's a real gap. I make some quite specific suggestions in the book as well, things around accessibility of information, ways to communicate with Ps and their family members and others. One thing I have suggested elsewhere and in the book is a rebuttable presumption of Ps participation in court proceedings, which I think would make a huge difference, because one of the things I've observed is that this is not a conspiracy to exclude P. This is often just people not even thinking about the issue, and it not being effectively kind of a central part of the decision-making process in the court. Whereas if you include a rebuttable presumption as part of, say, the Court of Protection rules, that would require individuals in each case to at least put their mind to considering how can P best be facilitated to participate. So there are some specific practical things that I think we could do immediately with the rules and provision of information, but I also think it's on the courts to also do some of that engagement work as well, to find out what people impacted by it, what court users would want.
Yeah, definitely. And I can see how, as you say, they're the ones with the access to these people easier than it would be for, researchers pitching up to say, can I speak to X, Y, and Z? So that is the challenge for them, really, isn't it? Put back onto the court system to actually work out how to include disabled people in their proceedings, I suppose. And that sort of brings us on to some of the evidence, I suppose, you talk about, which I found fascinating, hierarchies of evidence in one of the chapters, sort of the givers and the users, if you like, and who gets listened to. And you've talked a little bit about P in that process, but particularly perhaps the more formal kinds of evidence that is heard, the medical and social workers and so on. Could you just talk us through a little bit about that analysis of of the Court of Protection and that how evidence of experience, as you refer to it, should be used more?
Yes, so I think for a range of historical reasons, the Court of Protection has relied quite heavily on medical evidence in the past. That's certainly been, the research by others, like Paula Case and Alex Rockeen, similarly done research kind of coming to similar conclusions that there is a kind of preference for psychiatric or medical evidence, particularly about mental capacity, potentially less so about the best interest question. And that's something I also kind of argue in the book. I guess the role of experiential evidence, as I call it, comes both from professionals. So I talk about the role of social work experiential evidence. So what I mean there is, there's real value in having professional evidence from someone who actually knows, he has a long established relationship with them, who has engaged with them, over a lengthier period of time, who can really provide for the court a kind of vivid and full picture of their abilities, their likes, their dislikes, the kind of way that they make decisions in their everyday lives, in a way that usually an independent medical expert who meets people for an hour or two isn't able to provide. So there's value in that kind of experiential professional evidence, but also feeding into what I've said already in the wider theme of the book, that experiential evidence from P herself, and family, friends, and carers around P. And I think this is not just a problem with the Court of Protection. I think courts and legal systems generally have, a hierarchy of evidence, and they have evidential rules. And I don't think I'm saying in the book that, evidence from experience should outweigh the value of other forms of evidence, merely that it's just simply not even heard in the same way. And so the kind of procedural justice angle is about trying to put people on an equal footing at that stage of hearing the evidence, so that the evidence can be heard in a kind of more balanced way before the judge actually weighs that evidence up to come to a decision. And I don't think we've fully achieved that yet, partly through P's absence of participation and voice. And we haven't really, in the Court of Protection, thought through more creative ways of getting P's evidence before the court. There's been some criticism about judges speaking to P outside of court and kind of what the status or weight of that kind of evidence could be. And people are therefore, or judges are apparently quite wary about doing it because of that kind of lack of clarity around the legal status of that evidence. But I think it's still important to enable both forms of evidence to be heard. And I think there's a little bit of a fear around encouraging P into the courtroom to give, for example, sworn evidence, because there's a fear that, that's very scary. That is something that could be quite traumatizing for P, instead of thinking, well, actually, how can we make that experience better? Can we use familiarization visits, various forms of special measures to actually make that experience something that isn't so difficult for P, which would then enable all of the evidence to be heard and then to be weighed up?
Yeah, thank you. And that some of the examples that you go through in the book, and it was lovely to sort of get a real snapshot of the cases that you observed and the cases that you had been involved with, or both in the court and, of course, virtually. And that observation evidence that you had in the book was fascinating, and to see some of the things, I was particularly struck by some of the examples where there was one particular case you were talking about, H County Council versus XC, and the lack of a BSL interpreter. And I was trying to think, how would that play out in another court if there wasn't an interpreter, let's say from a race point of view, with a non-native speaking English, English isn't their first language. And that really struck me, that example from your observational analysis. So P is fairly crucial here, really, isn't it?
Oh, Absolutely. And, I think go back to points I think I make right at the beginning of the book, here we are talking about someone who has not committed a crime, has not done anything unlawful, but is potentially having highly restrictive, interventionist, you know, court orders made about what they can and can't do with their lives. And yet we don't seem to be giving them a full opportunity to participate and give voice in those proceedings that can have such a drastic consequences for them. And as I said, it's not it's not a conspiracy against P that people aren't thinking, well, let's just not have a BSL interpreter. I think in that case the judge may not even have realized that P was due to come along, because it is relatively unusual for P to attend a hearing, and instead of adjourn it to book an interpreter, perhaps, I don't know, I didn't have this discussion, but perhaps the thinking is, well, it's better to go on with the case. But if you kind of embed P as central to the court process, those discussions or those kind of thought processes have to happen in a different way, because you have to think, well, no, P is central to this, and we have to make sure that P can understand what's going on and can be engaged with and follow what's going on. So yeah, I guess in that final chapter, that's why I start talking about design thinking and how to kind of design courts better and engage with users better. And that's a process that I think is really important for the Court of Protection to go through and consult with all of the range of stakeholders, not just focus on the lawyers and the judges who are court users. And this is not just a problem of the Court of Protection. Most courts across England and Wales are designed for lawyers and judges, because they're the people who use them every day. But it's important not to forget the other court users, and that for other court users that these are exceptional moments in their lives. They don't use courts every day, and we have to remember that it's important to make them feel at relative ease and engaging with the court process, particularly in a jurisdiction like this, which as I said, is it's meant to be an inquisitorial jurisdiction that tries to resolve things in ways that are best for P. So one would expect that to be part of embedded into the process itself, and I don't think it always has been.
Yeah, and as you say, using sort of some of the design thinking that I know others are looking at. We often think of courts as just the buildings, don't we? But actually there's much more to a court than just that, and accessibility isn't just about physical access. It is about all of these other things and making it accessible to the widest range of people possible. No, that was really interesting in the book. I just wanted to turn to mediation. There's a chapter in the book on the process of mediation, and it would be great if you could talk us through that particular aspect, because I also think you can see some future work in this particular area, sort of future research, I suppose.
Yeah, so in some ways I think mediation seems potentially a little bit out of place in the book about a court, but I wanted to include it because I think we know that mediation is being used to resolve disputes in this area, but certainly at the time of writing there was almost no evidence at all. I think Charlotte May, a solicitor, had done a piece of work on court protection mediation, but other than that there was nothing really known about it. And so I wanted to include it in the book to think, partly to provide some of the empirical insights from the interviews with the practitioners about their experiences of mediation, and also just to kind of think through ways that the Court of Protection could be more flexible, more creative in, there is said to be more potential for mediation to be a more participatory process. That didn't always come through in the evidence from my interviews, but one can see that something like mediation, which can be more flexible for where it's held, the way in which the process is set up, it could potentially be more participatory for P. And so maybe that's something the Court of Protection should be engaging with more, to think through ways that forms of alternative dispute resolution like mediation might be a helpful way forward in this jurisdiction. So I wanted to include it in the book just to give some, some evidence about its use, but I think we it's something that it needs further work really to strengthen the evidence base. I'm currently, it has actually led on to a project I'm currently doing on the use of mediation to resolve medical or healthcare and treatment disputes. So that's a project I'm researching at the moment, but it really kind of developed from the work for this book to think, about, as I said, about the flexibility and creativity that mediation might provide in theory, but does that happen in practice in these types of disputes, which ethically challenging and have this overarching best interest question as part of them. I said in the book that there's real concern among lawyers about how can we ensure best interest is secured in mediation without a judge having that oversight. And then you have the critical theorists who will say, well, actually, mediation, there's power dynamics at play, and so they oppose mediation too. So there's lots of concerns about mediation, and I guess I just wanted to explore some of those concerns and also think through ways that mediation also might have potential. So yeah, it's led on to some further research, which I'm really enjoying doing at the moment.
Yeah, that sounds great. Yeah, so the future, immediate future for you is more of that sort of that work around mediation. Fabulous. So just from my perspective, I mean, it's a great book for all sorts of things, I think, for the socio-legal community. The methods approach, thinking through some of these issues, different theoretical frameworks. It really provides, I think, that sort of excellent scholarship for the socio-legal community. Any last thoughts from yourself about this particular area, this reimagining of the Court of Protection?
No, I hope, I guess, that it's firstly given people a bit of an insight into what you said. I think you said earlier, is a relatively less well-known area, even though it's an area that could actually affect any of us. Whether it's to do with the lasting power of attorney for a relative, or if we're in a car crash, or there's so many ways that we could come into contact with the Court of Protection throughout our lives. So hopefully it's given a bit of an insight into that. And also just to encourage people to do the empirical work that can often be time consuming and can often feel that it is not always successful in the early stages of that process, and just to encourage people to do it and take the time to do it, because it's really valuable, and I enjoy it so much, and I'm pleased to have been able to put it together in the book in this way.
Yeah, fabulous. Thank you very much. That whole issue about choice, you're right, it could totally affect any of us at any point. And that first sentence in your introduction about how we all live our own lives and we make our own choices, preferences, whether or not they're good ones or not, or and then imagine, yes, the court being able to take all of that away from you, and that just really, it really strikes you as, yes, we should be teaching this to all the students. We should be talking about it more, certainly. Anyway, just say a really big thank you for joining me today and spending some time talking through your book. And yeah, we'll leave it there. Thanks very much.
Thank you very much, and thank you obviously to the SLSA as well for the prize and the funding previously.